What is exempt under Florida law? That's a huge question, probably a show in and of itself, but I'm going to give you a basic rundown. Florida has a wonderful homestead exemption. It means that if you've got a homestead in the state of Florida and you're a Florida resident, let's say you've been living in Florida 5 years, you're entitled to what's called unlimited homestead equity exemption. What does that mean? That means that if you have a house worth $5 million and you have no mortgage, no promissory note, excuse me, live TV, can't get a break. 1 second, folks. That was good. Okay, get back to the $5 million house. If you have a house worth $5 million, no mortgage on it, no creditor can take that home from you. Your equity is exempt. It's kind of like saying, I've got a $5 million asset right here. I'm going to take it off the table now, creditors, because you can't touch it. Second exemption that I always tell people about is your automobile exemption. You're entitled to protect $1,000 worth of equity in a car. So if you have a husband and a wife in a marriage, you have the husband's vehicle, if it's titled in his name alone, he's entitled to protect $1,000 worth of equity on that. Same thing with the wife. What if you have a lease vehicle? Well, lease vehicles really have no equity in them, so I don't even list them down there on Schedule B because they're lease vehicles. They go in a separate section of the bankruptcy schedules where we list all the leases. Unless there's something in the lease, excuse me, which requires like a refundable security deposit. That is an asset which can come back into the bankruptcy estate. So I would have to exempt that under the third category. Your third category is going to be your personal property. Here's where it gets a little sticky. In future shows, we're going to show you how this breaks down, and let me tell you why. There's kind of a flux in the law in here. Back in July of 2007, the Florida legislature came out and said, we're going to give an extra exemption, called a wild card exemption, to individuals who do not receive the benefits of a homestead exemption. What does that mean? Right now, the courts can't decide. The first set of courts who got this were the bankruptcy courts because that's where exemptions are applied all the time. So the initial ruling was, well, if you're keeping your home or if you've expressed an intention to keep your home, you're getting the benefits of a homestead exemption and therefore you're not entitled to the wild card. Recently, we've had a ruling from a judge in Tampa who said, well, if your house is upside down, I mean, you've got $100,000 of negative equity, you're not receiving the benefits of a homestead exemption if you decide you want to keep the house because really you're not exempting anything. There's no equity to exempt. And if you want to keep the house, that's fine because the bankruptcy court's not going to do anything with this house anyway. So therefore, that person was entitled to the enhanced damages. Well, there's a case right now in the federal courts, and the federal courts have certified the question to the Florida Supreme Court. So everybody who has anything to do with this issue is waiting for the Florida Supreme Court to rule. Could they rule this week? Yeah. Could they rule next week? Yeah. Could it be a month or two? Yeah. But the problem is, by waiting, with the Florida Supreme Court holding us back, we have a lot of clients in the pipeline who want to take advantage of this wild card exemption, the extra $4,000 I'm talking about, and it would be really nice if we could know. So if anybody from the Florida Supreme Court is watching, let's hurry up a little bit, all right? The next question, or the next exemption that I like to tell people about is 401ks. If you have money in a qualified 401k program, fantastic. It's 100% protected. Same thing with your IRA. But the government chose to cap out IRAs at $1 million. Luckily, I've never had a client who's had a problem with $1 million or more IRA. But if you do have more than $1 million in your IRA, probably not a good idea to file bankruptcy. The next one is life insurance policies. You got basically two different types of life insurance policies. You got a cash surrender value whole life policy, and you got a term policy. Term policies we don't really have to worry about because they term out. In other words, if you term out in 6 months, you're basically rolling the dice that you're going to die within 6 months. If you do, bad for you, good for your beneficiary because now they're collecting. But the other type of insurance policy is the whole life policy. The whole life or some type of whole life policies, if not all of them, build what's called cash value. The good part is Florida law actually protects the cash value of those policies. So it's more of an investment vehicle, but at the same point in time, you know that that money's there, it's protected. Now, if you ever need to go borrow against it in the future, you could, but that's got its other issues. So if you're in a Chapter 13 and you're thinking about borrowing against your cash surrender value, go talk to your attorney, please, before you do it. it could have ramifications on your case going down the line. Another exemption is annuities under Florida. Now, a lot of people don't know what annuities are. Basically, annuities are investments. You buy it, let's say you buy a $10,000 annuity today, but you don't want to start collecting on it till you turn 65. So for me, that would be about 20 years away. So I put $10,000 in, I let that money grow for 20 years, and then when I turn 65, it starts paying me back, hopefully, $250 a month, so that I get my net benefit back plus all the accumulated interest for a certain period of time. Florida law protects those. Now, you got to be real careful. Whenever I get somebody with an annuity, I always call up the benefit provider and I say, hey, what's going on with this? Is it protected? Blah, 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 blah. We do our due diligence, because I don't want to go into court one day and say, yep, my client's got a $500,000 annuity, and find out it's not protected. So that one you always got to do your due diligence on, be a little bit careful of. Those are the main exemptions that we have.